Good morning to all. Today we have a discuss about the topic is namely the intellectual property. So before we are going to session, let me introduce about myself. I'm Dr. Ravichandran, Assistant Professor, Department of Physics, Erode Singh Engineering College. And now we are going to session the intellectual property rights. So what are intellectual property rights? The intellectual property rights are given to the persons over the creation of the minds. That is the general concept. But the usually give the creator and exclusive right over the use of his creation for the certain period of time. So it's nothing but the general intellectual property rights is nothing but intellectual property rights are given the rights to given the persons over the creation of the minds. But in general, it has been classified two types. The one is copyrights and rights related to the copyright and industrial properties. In addition to that, the people are majorly classified the four types. The one is patent, another one is copyright, and the trade secret and trademark. These are all the intellectual property rights and classification of intellectual property rights. So now we are going to the session that we are going to discuss the concept of IPR and history of IPR and rights related to the IPR means the intellectual property rights and branches of IPR, an emerging issue in IPR and benefit of IPR, and finally the conclusions. The intellectual property rights, we have discussed the rights to given the person over the creation of the mind, but here the word is right and property and intellectual. So intellectual means already we know that we don't go with the in-depthly relating to the intellectual, that is intellectual property, and property means a thing or things belonging to the someone, and rights to a moral or legal entitlement or to have or do something or prevent other from the doing something. These are all the rights. So then we can conclude the intellectual property rights. So the next some other rights are given below. According to the World Intellectual Property Organization WIPO, the term intellectual property indicates a legal rights resulting from the intellectual activity in the field of science, industry, literature and art, some other research. And in general, the right of an inventor to derive the economic benefits from his invention, the rights which can be used for protecting the different aspects of inventive work from multiple productions. So generally, they usually give the creator an exclusive right over the use of his or her creation of the certain period of time. The outline of outlined in Article 27 of the Universal Declaration of Human Rights, and the IPR are largely traditional rights except copyright, which is the global in nature, and intellectual property can be assigned, gifted, sold and licensed like any other property. That is the simple introduction about the intellectual property rights. And here the history of intellectual property rights in India, and they start with the 1948 in the trademark protections. The Indian government they have given the property rights in India, and 56 in the Act of Protection and Invention, and 57 Indian Copyright Act, and 59 Indian Trade and Mercantile Mark Act, and 1970 Indian Patent Act, and 1999 the Geographical Indication of Goods, and 2000 the Semi-Conductor Circuit Layer for designing the art, and the protection of plant varieties and farmers' right to act. These are all the intellectual property rights, and the government agreed in the property rights in India. The intellectual property includes the right and related to the literary, as before we have discussed in the four type of classification. The one is patent and copyright and Indian secret and Indian patent, Indian copyright. So it includes the literary, artist and scientific works and performance of performing artist and phonograms and broadcast. In addition to that, the invention in all fields of human endeavor and scientific discoveries, industrial designs, and as per we have discussed the trademarks and the protection against unfair competition. These are all the includes of intellectual property rights. So the branches of IPR. So the first one is the patent and copyright and trademarks, designs and traditional knowledge and the confidential information and plant validity. These are all the in general branches of intellectual property rights. And we have classified the enormous classification, but we have to mainly focus on the few type of branches of intellectual property rights. And it has been continued. There are many big and small intellectual property law firms worldwide, like in India, USA, Chicago, and some other countries, providing the qualitative help to inventors and creators of the product. And in India, the intellectual property rights are safely protected and controlled with a well-established statutory and judicial framework. That's what I'm saying as before. Some of the act as given in the Indian government. So apart from that, there are many awareness and law firm of intellectual property in India in various states. That is the legal Ministry of Committee of Industry, like Patent Office and Trademarks, and the Patent and Corporate Works under the Ministry of Human Resource Development, and that is the Government of India. And Protection of Plant Varieties and Farmers Right Authority works under the Ministry of Agriculture and through the Government of India. And the main forms of IPR, patents, it has been classified the patents, copyrights, trade secrets, and plant breeders' rights. And in general concept, the idea of expression, idea plus expression, it could be given the copyright. That is called the copyright. So we have to give a idea plus expression, that is called the copyright. A right which is available for creating an orderly literary or dramatic or musical or artist work. These are all the copyright form. I mean the idea plus expression. And in India, the Copyright Act 57 is amended in the 1983, 84, 92, 94, and 99 is available. It could be covered the idea plus expression, and we can get the copyright from the Indian government. And registration can be done at the Office of Register of Corporates in New Delhi, and protection for the expression in the idea, and not for the idea itself, and general rule the copyrights laws for 60 years. So this is the copyright includes, you can see that the picture, and the first one is literary, films, and dramatic and musical, artist, and sound recording. So this is the copyright include. That's what I'm saying. The property rights are rights given the person to persons over the creation of the minds. So what is not covered in the copyright? Some other things are available. You can see that the picture and ideas, facts, recipes, works lacking of originality, for example, the phone book, names, title, or short process. These are all the not covered in the copyright. The case studies in Bangalore on August 10, 2003, and Banashankari police arrested the 3 software engineers for a illegal copying software from the company they were working for. And Chennai, likewise the Chennai, February 2000, the created software worth in 1.11 crore was seized by the Chennai police. A total of 6 employees were arrested, which include the managing director of the one outlet and the properties of each of these outlets. And next we are going to discuss the patents. The Patents Act is 1970. So as per I've told you, like as a copyright, idea plus expression is equal to copyright. Likewise, the patents is idea plus innovation plus invention. It could be covered in the patent. So generally the patent is monographic rights granted by the state to exclude others from the exploiting or using the particular invention. And the idea plus invention plus innovation, which is equal to the patent. So they can conclude the exclusive right granted for the country to the owner of an invention to make use the manufacture, the market the invention. So the patents provides the incentives to individual by recognizing the creativity. The incentives encourage invention, and it prevents the direct copying of invention, makes competitors to find the solutions. So patents are granted already we've discussed the invention and innovation and process, which means product of invention, concept, and requirement for the grant of patent, the novelty, inventiveness, and industrial application, and usefulness and disclosure. This is the granted for the patent and requirement for the patent. So the type of patent is the 3 basic types: the utility and design and plant patents. The utility is general. We have discussed the useful devices and process, And design is appearance of useful devices. And plant patterns, man-made plant varieties. And invention is not patternable, the century public order or morality, and the mere discover of scientific principles, and the mere arrangements of or rearrangement or duplication. This is the not patternable. And any process for medicinal and surgical, curative, and prophylactic and diagnostic therapeutic, these are all the not patternable inventions. So the plants and the animals involved or any part of therefore other than the microorganism, but including the seeds, varieties, and species, and the essentially biological process for a production or propagation of plants and animals. These are all not pattern of invention. So next, likewise, as we have discussed the copyrights and the patents, so likewise the trademarks will be continued here. The idea plus quality plus identity, that is called the trademark. Okay. So already we have discussed idea plus expression is copyright. So next the patent is idea plus innovation is equal to the patent. But here itself the trademarks are idea plus quality plus identity is equal to trademark. So trademarks can be in general word, the name, brand, symbol, label, etc. used by the company to create the unique identity of the product, likewise the Coca-Cola and Pepsi and so on. And a trademark can be registered and then use the TM circle in the O. The registration validity for 7 years and renewal after expiry in India is governed by the Trade and Mercantile Marks Act 1958, which came into the force 25th November 1959. So you can see that trademarks, you can see the name, logotype, symbol, slogan, and shape, color. And the logo, I am loving the orange and the tick mark like this. This is the logo of Coca-Cola. And the distinctive sign that provides the owner of the mark, ensuring the exclusive right to use the identify goods services. The example of trademarks and trade secrets, the invention, idea, survey method, and the manufacturing of the process, experiments, results, chemical formula, recipe, financial strategy, client database. These are all the trade secrets. And when trade secrets are preferred, the not patternable, unlimited life, cost, and difficult to reverse the engineer, these are all the trade secrets. Okay, so now we are going to, already we have discussed in the what are intellectual property rights and what is the patents, copyrights, and the trademarks, the so on. And further we will study in the next video. And thank you so for your kind attention.